Thank you, Mr. Assistant President. I rise on behalf of the Greens to indicate our strong support for the motion that's been moved by the Honourable Robert Brown and to indicate our opposition to the amendments that have been proposed by the government. Mr. Assistant President, for well over a decade, there has been this cloud hanging over the New South Wales Police Force, which arises from a series of extraordinary warrants that were quite literally rubber-stamped by the Supreme Court between about 1997, 1998 and 2001 and 2002. And those warrants were obtained by a number of crimes agencies, by Police Internal Affairs, by the Police Integrity Commission and by the New South Wales Crime Commission. At different times, two of those agencies operated together in Operation Mascot, and then the Police Integrity Commission at a later point had Operation Florida. It's a long and complicated and difficult history. There was eventually, after real concern was raised about how these warrants were literally being handed out like confetti by the Supreme Court, there was deep concern raised within the New South Wales Police, which led to a strike force emblems being undertaken, being put in place. Strike force emblems tried to get to the bottom of it, tried to find out how on earth this had happened. But of course, they were stymied in their investigations because when they tried to ask the Crime Commission officers about what their involvement was and how it was that these warrants were being issued by the Supreme Court, they were threatened by the Crime Commission with criminal proceedings for breaches of the Crime Commission Secrecy Act. And they were constantly stymied in getting to that. Strike Force Emblems eventually delivers a report, which on any view of it, was a deeply, deeply critical report of what on earth went wrong, limited by the information that they couldn't get from the Crime Commission because of the failure to cooperate. What happened to that report? It was buried. And it was buried by the former government and it was not disinterred by the current government. What did the current government say in opposition? Well, they made all sorts of promises that the truth would finally come out, that they would shine daylight on this, that they would table the reports. No. And what did happen? And what did happen?
A lie.
What did happen?
You know that's a lie.
I'll give you the courtesy of acknowledging your interjection.
That is a lie.
But I'll also respond to your statement. The clear impression amongst all concerned was that and fostered by the coalition in opposition was they would produce openness, they would produce transparency, and there was a promise. I think the parsing that the government is using about the recommendations or the body of task force emblems. There's this parsing in truth about whether it's the recommendations or it's the body of task force emblems. You'll get your chance.
Yeah,
you'll get your chance. And did they table it? No, they didn't. Did they table the report? No, they didn't. Did they table the recommendations? No, they didn't. They then refer the matter off to the inspector of the Police Integrity Commission. And the Honourable Adam Searle has dealt with that history, and I won't traverse it again. There has still not been a tabling of the report of task force emblems. There has still not been. And at the time that Justice Levine was undertaking the review, it was not apparent to the public that Justice Levine had been one of the judges who had been signing off on the warrants. That only became apparent in 2013 in the course of questioning in the face of the Ombudsman's Pick and Crime Commission hearing. And I'll read onto the record one of the exchanges between the Chair and Justice Levine about what exactly his role had been in signing off on the warrants that should be the substance of this inquiry. What had been the inspector's role? I'll read it. The Chair asked, is the veracity of the information they put before that judge, and we're talking now about the affidavits and the supporting material that's put before the judge in an ex parte hearing where it's just literally the police and the judge, and the police or the Crime Commission or the PIC are seeking to get the warrants. It's an ex parte hearing. No one is there to test it. Is the veracity of the information they put before that judge open to any form of scrutiny or testing? If the information that was put before the judge was flawed or incompetent or misleading, are there any means by which that could be detected and addressed? The very question, I think, that goes to the heart of this inquiry, that should be going to the heart of this inquiry. And this is what Mr Levine said. The first means would be some internal flaw or inconsistency in the form of the warrant or in the affidavit in support of it. From my own experience, it is now about 8 years ago when I last was a duty judge issuing such warrants, I, like any other judge, developed an idiosyncratic methodology for reading this material, which at times would come in inundating waves, one after the other. I do not want to diminish the process, but I said, I'm going to look to see if there is someone named in this warrant who is named as M. Mouse or D. Duck. I did that. That is one way. That was his integrity test. He checked to see if there was something so obviously and grossly flawed in the list, such as the name of Mickey Mouse or Donald Duck. And I won't read on the balance of the transcript, but it becomes apparent he had no genuine capacity to test what was being put before him. And what was the result? Well, the result was warrant after warrant after warrant after warrant after warrant being issued, with nobody checking. Why were the warrants being issued? Were they being issued to deliver internal vendettas within the New South Wales Police and other crime agencies? A very real concern that that was what one of the purposes of the warrants were. Were the warrants being issued for a lawful purpose on the basis of credible information? Were people misleading the Supreme Court? Because it is very clear from further statements that have been made following investigations that there were warrants issued naming scores of people, giving warrants against scores of people who weren't even named in the affidavits that are put before the judges when they're signing off on them. You couldn't even match the name to the name on the warrant to a single shred of evidence in the affidavits that have been presented to the courts. But they're stamped, they're stamped, they're stamped. Wiretaps, intrusive covert surveillance is operating as a result of that. That's what needs to be the subject of serious, public and open investigation. When I sought to raise these matters in budget estimates in 2012, I was shut down by the government. Shut down by the government, and the response was, following shutting me down in budget estimates, to hand the matter over to the Ombudsman with a suite of new secrecy powers. 19A, 19B and 19C, a suite of new secrecy powers were put in place. Just before the Ombudsman received, and welcomed the receipt of the referral and the new powers, I had spoken to the Ombudsman. I think it was on the 21st of September that year, 2012. And I said to the Ombudsman, I have a bunch of material here which raises deep concerns about what went wrong in this wiretapping exercises. I said the Crime Commission, the Police Integrity Commission and Police Internal Affairs have all been implicated in it to date. You are literally the last person standing who isn't implicated in it. And I know it's been referred to on a number of occasions over the last decade, and I would urge you to take this material that I have and undertake your own investigation. Have a look at it. Look at what went wrong in 1999 and 2000. And what did he say to me? I don't want to see the material. I'm not the right person to do it. I don't have the right powers to do it. I said, I can't believe this. I have a folder of material that I want to give to you to look at serious issues of potential criminality in the way that these warrants were issued in 1999 and 2000, and the response has happened since. I do not want to see the materials. I don't want your materials. I don't want to meet with you. A matter of weeks after that, the Ombudsman welcomes the receipt of the referrals, welcomes the receipt of the inquiry, and gets a raft of new secrecy powers given to them by this Parliament. 2 years later, we still don't have any outcome, and we still have 2 years of further secret hearings, further secret witnesses. Witnesses who are called before the Ombudsman are then gagged under the new secrecy provisions. They can't even say that they've been called to go down and give evidence. They can't say that they've been the nature of the questioning. A complete gag. A complete gag. A complete gag. 2 years of it. 2 years of it. And then what do we find? No public accounting from the Ombudsman. No efforts of public hearings or private hearings. Everything is private in this Ombudsman's inquiry. Unlike in ICAC, where you have the matters that can be in the public domain are in the public domain, the matters that need to be in private are in private, every single part of this Ombudsman's inquiry has been shrouded in secrecy under those new secrecy provisions. 2 years of secrecy, looking into a secret police report, looking into secret covert surveillance. When did New South Wales become this secret covert state? Well, it's got to end. It's got to end. It's got to end. And then, if there is one thing that is most deeply troubling in what the Ombudsman's letter of the 11th of November says, it's the phrase where he says this: Operation Prospect is also examining allegations that confidential information from the New South Wales Police Force, New South Wales Crime Commission and or the Police Integrity Commission computer systems has been unlawfully disclosed. And in this context, my office has received a large number of complaints concerning serious misconduct by officers of the New South Wales Police Force, the New South Wales Crime Commission and the Police Integrity Commission that fall within the scope of Operation Prospect, and each of these complaints must be considered and responded to alongside the broader investigation. In other words, what's derailing on the face of this? What's derailing the delivery of the Ombudsman's report? What's causing the delay? A secret investigation by the Ombudsman into whistleblowers. He wants to find out who put the small amount of information into the public domain that finally shed a small amount of light on this that eventually led to his own report. It's an investigation into who gave the public a small amount of information. Why is it 2 years in delay? Well, it probably takes 2 years to run every whistleblower you can down to ground, to seek to uncover who had the temerity to actually demand some public accountability and end the secrecy in New South Wales. It's not only urgent, it's not only proper, this is the job for the Parliament. It's the job for the Parliament to shine light when nobody else is willing to do it. I commend the mover of the motion. I commend